Yeah, I think I'm good.
Awesome. Hey, Jim Wright, thank you.
Okay. Thanks, Jason. Sure appreciate that very, very kind introduction. And we are happy to be here to talk about land use appeals and variances. So I'm Jim Wright, as you mentioned, from the Office of the Property Rights Ombudsman. And, it is great to be here and appreciate the trust in Jason inviting us and giving us a chance to talk about these issues. So as Jason mentioned, I'm happy to take questions during this presentation. If you also would like to talk to afterwards, basically if there's a question that comes up you think might merit a little bit more of a discussion and back and forth, please don't hesitate to call. I have our contact information on the very last slide, and we've done this lots of times with people after these presentations where we followed up and had really good conversations. So that's absolutely available as well. And the whole point of these, we're trying to give information that's going to be helpful to you. And so, even if that includes calling and following up, great. We're happy to do it. And along the lines of giving information that's hopefully helpful, I will, again, just let you know I've put way too much information on each slide. I know I violated all kinds of PowerPoint protocol, but the hope is that you will then have the information in written form that you can refer to quickly without having to go back and wade through a boring attorney talking about stuff on and on. But so I put the stuff in the slides and have included citations to both statutes as well as case law to the extent that it is relevant. And also with this topic, it's possible to get off, certainly, as with many land use topics, into the weeds and the minutia. I've tried to keep it pretty focused on what I think is going to be relevant and helpful to you guys based on what's going to happen in 95% of the cases. But again, the whole hope here is that we'll have something that will be relevant to you and some takeaways that will be useful. So let's jump in. So we're going to go over land use appeals. We'll be talking about appeal authorities and the appeals to appeal authorities, and then appeals to district court. And then I'll go over a couple of case studies so we can see some particular fact patterns and how Utah courts have addressed them. Variances, we'll go ahead and go over the requirements for variances. They're set forth in Utah statute. And then we'll go ahead and look at some case studies there as well. In order to try not to be too boring, I try to put pictures on every slide. Some of these it's a little difficult to think of pictures for. This one here is from a video that our office did. Brent Bateman, our lead attorney, he's really good at doing videos and coming up with scripts, and this is one that he invited me to participate on. I thought we kind of look like a land use authority. The thing is, though, is he asked me to participate as a boring attorney. And he said, you know what, Jim, just be yourself. You'll do fine. So hopefully we won't have too much boredom today. But anyway. Okay, land use appeals. So generally speaking, there's an appeal process and standards in the Land Use Development and Management Act, or LUDMA, in Utah Code there. And there's a separate one, 10.9a, as you know, for municipalities, and then 17.27a for counties. And for simplicity's sake, I have cited simply in my presentation to the municipal LUDMA, but there are parallel provisions in the county LUDMA. And so, again, it's just there's already a lot of clutter, as I mentioned in here, so I tried to reduce that where possible. And it was not meant to suggest that there was anything different in the county LUDMA or to disrespect counties in any way. So, but just want to make sure that was clear why I did that. And so the process and the standards that will be followed for these land use appeals will depend on the type of decision at hand. And namely, there's two major distinctions. One is the decision an administrative decision, which basically means that you are applying law that has already been made to a set of particular facts or a specific situation? Or is it a legislative decision? And a legislative decision is made by the legislative body and it makes law. I don't want to get too far afield on this issue because honestly we could spend a lot of time on this because it's a very important distinction. But here is a table that Brent Bateman, our lead attorney there in the office, made a few years ago that I think is really helpful for having a quick view and a quick understanding between legislative decisions and administrative decisions. So again, you see here on the legislative decision, it's making law. It's things like ordinance adoption, general plans, zone changes, that sort of thing. And administrative decisions are applying those laws. So a conditional use permit, subdivision, building permits, those types of things. And the legislative decisions are always made by the legislative body, so it's going to be your council or commission. The administrative decisions can be made by a whole bunch of different people, including sometimes the council or commission. And it's important to understand that it is not the body that is making the decision that determines whether or not it is a legislative decision or an administrative decision when it is the council or commission. They can also make administrative decisions, and the laws that apply to administrative decisions will apply then to those decisions, even if it is that legislative body. We'll get into more of this detail here as we go along, some of it at least, but again, I just want to throw this out there so you could see it. We'll talk about the standard of review and the discretion, remedies, etc. Okay, so the appeal authority. So under state law, each municipality or county has to have, it's mandatory, must have one or more appeal authorities. And so there's some discretion, though, one on the number of appeal authorities that you have, as well as on the composition of these appeal authorities. So some jurisdictions are now trending towards having a hearing officer hear the appeals. Traditionally, this has oftentimes been a board of adjustment, a multi-body group that's going to be subject to open meetings laws, whereas the single person, would not be subject to those same laws. But the point is that you have to have at least one, and you have some discretion in the format and the composition of these appeal authorities. And appeal authorities under statute, they act in a quasi-judicial manner. That's fancy speak for saying they're acting like a judge would, basically, in terms of they're there to try and determine what is the correct outcome for this decision based on the law. They are not there to try to decide what the best policy is or how they would like things to come out, or working with people on the side to try to say, hey, I really like what you're saying here. I think I'm going to fine for you guys. I mean, they really have to try to act as if they were, making a judicial type decision, which they are making. The appeal authority has to be different from the land use authority that made the initial decision. Hopefully there's obvious reasons why that would be the case, but even more than that, say for example you have a hearing officer, a single person that makes the appeal decision as your appeal authority. Say that person were on a commission that made the initial decision. That person would be disqualified from making that appeal decision. So appeal authorities under the state statute, they decide the following items: the request for variances. And we'll go ahead and talk about variances here in a little bit. They're their own little separate part of this presentation, and they have some separate standards under the state statute there, under LUDMA. Appeals from decisions, both interpreting and applying a land use ordinance. And then appeals from certain fees. We're not really going to talk about that, but I threw that in there just because that's in the law, and since we're talking about appeal authorities, I just want to give you the three things in the law that they do. So appeals to appeal authority. And again, these are talking, let me go back here real quick. So appeals from decisions interpreting or applying a land use ordinance, that's important, because what is absent there is an appeal from a legislative decision to enact a law. Okay, that's not what we're talking about here when we're talking about appeal authorities. If someone disagrees with an ordinance passed by the council, their remedy is to go to court, not to an appeal authority. Okay. And we'll talk briefly about some more distinctions there in a little bit when we get to the district court, differences in standards there that the court will use to review the decisions, whether an administrative or legislative decision. So appeals to the appeal authority. So the applicant, the municipality or county, a board or officer of the government, or any person that's adversely affected may appeal. So this is not just limited to the applicant or the government. Neighbors, as you're certainly aware, have a lot of interest a lot of times in these types of decisions, and they have the right, if they are adversely affected, to appeal a decision. Under state law, you have to have at least 10 days from a written decision to allow people to appeal to your appeal authority. This is really important because under state law, if you miss this deadline, this time period, you are cut off from appealing that decision, and you cannot go to court. It's over. The decision stands. This is a really bright line rule, and it's a very it has harsh application if you miss that deadline. Now, it does not have to be just 10 days. You can set a longer time period. You just have to have a minimum of 10 days under state law. So the question sometimes can become, though, well, 10 days from what? Because in certain decisions, for example, a building permit, it is not going to be obvious to anybody other than the applicant in the governmental jurisdiction that there's been a decision that is appealable. You know, the written building permit has either been issued or a written denial has been issued. And oftentimes, as mentioned above, you know, neighbors have some interest in this, and they do have a right to appeal. So this case here, Fox v. Park City, deals with a situation where a neighbor did not have notice about a building permit that was issued until this neighbor noticed that the building that was being constructed violated height requirements. And so as you can imagine, by the time you're noticing that a building has violated height requirements, there had been some time that had passed, many months, between the time that the permit was issued and the time that this person wanted to appeal. So the Utah Supreme Court ended up getting this case and had to decide, well, when is the time that we're going to say the appeal starts running? And they were grappling with the fact that, well, we have an appeal right under statute, and so if we just have 10 days from the time that a building permit is issued, or a permit like that where there's not really any public notice, then the right of appeal is really meaningless, and we can't do that. The flip side is, if we let someone appeal, you know, 6 months after the permit has been issued and they've spent all this money constructing this building, that is not equitable either. And so what the Supreme Court settled on is there has to be actual or constructive notice of the decision. So they said, look, you know, you can either have something, you know, posted on the property that's visible for passersby saying, notice there's been a building permit that's been issued on this property, and gives people a chance to go and take a more careful look at it. Or when you see construction equipment on a property doing things that would require a building permit, then from that very first moment, then you're put on notice that the decision has been issued, and the clock will then start. So I just wanted to get that out there. Sometimes it's obvious, you know, Planning Commission meets, they vote up or down on a conditional use permit, put it in writing, okay, clock starts. But other times, as I mentioned here, we just talked about, it's not so obvious, so just keep that in mind. And so some jurisdictions and some landowners will go ahead and post notice if there has been a land use decision that they want to go ahead and start the clock running on sooner rather than later. On further issues here, so you appeal to an appeal authority. So who has the burden of proof? And under state law, it's the appellant. And so whoever it is that appealed it needs to show that the land use authority made a mistake. Okay? And it's important here, in this, there's a requirement that you have to respect due process rights in state law. This would be applicable under the Constitution in any event, because it's important to remember that when you're dealing with appeals of land use decisions, you're dealing with property rights. And property rights, as we all know, are protected under the U.S. Constitution, and due process is going to apply. Now, the biggest thing to respect due process, in my view, is to simply follow the ordinances that you have and other laws in the state code, you know, in state statutes relating to the appeal. I say that's the number one thing. So follow your laws. Whatever it is, follow it. Have them, one, and then two, follow them. Another thing is you're going to want to give the property owner a chance to have, you know, the hearing, but to be able to speak. Again, typically when you're doing a due process analysis, people have the right to a notice and a hearing. And if it's their property right, they're going to want to be able to have a chance to speak. So once the appeal authority makes a decision, then what? In case some people still aren't happy with it and still feel like there was an error made. So there is a threshold requirement before you can appeal to district court on these decisions, and that is you have to exhaust your administrative remedies prior to an appeal to court. What does that mean? Basically, that means you have to, for an administrative decision, so from a land use authority, you have to go through the appeals process set up in the local code. And so you have to have gone to the appeal authority, and you have to have received a decision from them. And once you have that, if it's still not something you're satisfied with, then you can go ahead and appeal to the district court. Now, if it's a legislative decision, there is no local appeal authority. There you go straight to the district court. Who can file this? Well, same situation. Any adversely affected person can appeal to the district court. And person under these statutes is defined as, obviously people, but corporations, municipal, and county and governmental bodies as well. There is likewise a strict time cutoff here for the appeal from the time that the decision is rendered. And that is, under state law, this is 30 days. You have 30 days from the final land use decision to appeal to the district court. And again, if you don't get that appeal in, it's a strict bar, meaning you're done. Now, when a decision is appealed to the district court, there is a presumption that the decision made was valid. Okay, that's important. So the court isn't going to start from scratch and decide the issue all over again. Let's look at the standard of review that a court in Utah needs to use to determine whether or not a land use decision is correct. So this is the standard. This has been codified from the common law, from our cases. A decision will be upheld as long as it's not arbitrary, capricious, or illegal. I think we need a little more clarification on that. What in the world does that mean? Okay, so it's illegal if it violates a law, a statute, or ordinance in effect at the time the decision was made. Okay, straightforward enough. You cannot, obviously, with your land use decisions, violate the law, either your local ordinances, state law, or any sort of federal or constitutional provisions that apply. Can't do it. Illegal, won't be upheld by the court. Now, the arbitrary and capricious standard, that is where there is a distinction between legislative matters as well as administrative matters. So for a legislative matter, it's going to be upheld if it's reasonably debatable that it's in the public interest, if it's in the general interest of the general welfare. That's a pretty low bar. These types of cases are hard to win if you are arguing that the decision was not in the public interest. Possible, certainly possible, but it's a pretty low bar. For administrative matters, the standard is a little higher, but it's still not super high. The decision simply has to be supported by substantial evidence in the record. And substantial evidence, that sounds like you've got to have some major evidence here. Substantial is substantive. The reality is the way courts have defined substantial evidence, the term of art, it just means that it's enough evidence to convince a reasonable mind to support a conclusion. It does not have to be the best evidence, and it does not have to be the preponderance of the evidence, and a court is not going to look at this evidence and weigh it anew. They're simply going to go in there and look and say, was there enough evidence here on the record, and that's a key point, it has to be in the record, to convince a reasonable person to support this conclusion. That's it, okay? Now, please, yes. Thanks. I was going here and did not see this question. So let's see, do all administrative remedies need to be exhausted if the case involves an alleged violation of the federal? Okay, now that's going to be under federal law, and I will, I'm going to punt on this by saying I don't know offhand what the remedies are for a federal violation. My sense is that if you have alleged a federal violation, that you may be able to end up not having to exhaust your local remedies under state code for state law. But I will hedge on that a little bit, and that's something I would say, hey, give us a holler here, and we can discuss that a little more. That's it's not a question that I've ever had come through the office, but given that we focus on the state law and issues, but I'd be happy to take that one up and follow up on it. So yeah, I'll leave my answer at that. But thanks for the question. Plus it helped sort of break me up a little bit. I was getting in too much of a role here. So on this question of substantial evidence, it has to be more than just public clamor. And there's a case law here on this, and we'll look at that here in just a second. But it can't just be people coming in saying, you know what, think of the children, or my property values, or whatever it is that you hear over and over again whenever you're making a land use decision. So let's look at a couple of case studies here, and we can get into this a little more. So in the first one I want to discuss here, Springville Citizens v. Springville, this related to a planned unit development application. So the developer came in, proposed a planned unit development, and over the course of like 18 months, there were lots of meetings. It went back and forth, and requirements and alterations to the plan, and public hearings and meetings. Excuse me. And lots of changes happened, and there were professional views, staff views, all sorts of things happened. And ultimately, the jurisdiction ended up approving the planned unit development after all this time and back and forth. And some neighbors sued. And ultimately, the Utah Supreme Court said, you know what, it wasn't illegal. And they found, looking at the record, that there was evidence, that there was enough substantial evidence in the record to support this decision. And they specifically called out the number of meetings that had happened, the amount of time that this was considered, and the extensive accompanying documentation that was used for this type of decision. So those are things that a court has specifically given to us as factors, where the Utah Supreme Court has determined that there was substantial evidence in the record. Okay. Here, let's look at a case where the opposite conclusion was drawn, and that is the Wadsworth case. So in the Wadsworth case, the Wadsworth Construction wanted to go ahead and get a conditional use permit to have outdoor storage at their facility. And Dannon was a major presence there in West Jordan, and the West Jordan city had exerted a lot of work to get Dannon to locate there with their facility. And Dannon came to the meeting for the conditional use permit and said, you know what, we're really not excited about this. We think it's going to attract rodents, and it's really not what we're looking for around our facility. And some neighbors came, and they likewise said, you know what, not really our favorite idea here. There's going to be dust and other problems. We just don't think this should happen. And so the decision came down that the conditional use permit was denied. Now, in this case, the appeal went to the city council. And the city council, as the appeal authority, said, you know what, we're going to deny this conditional use permit. And they went through and they had certain findings that it wasn't in the public interest, and that all this effort came to getting Dannon here, and it wasn't the best use, and it wasn't in the general welfare. And they had these specific findings in the record, but there was nothing else to support it other than the comments and the testimony from the Dannon and the neighbors saying general things like rats, vermin, dust, not really the best idea for our neighborhood. And so the court ended up looking at this and said, we are overturning this decision. Okay, the decision made cannot stand because there was not substantial evidence in the record to support your decision. But whoa, we're the city council, they said. Courts need to give a great deal of deference to the decisions of city councils, they said. And the court said that's true when you are acting in your legislative capacity. Here you are acting in an administrative capacity, and it doesn't matter who you are. The standard required for administrative decision review will apply to you, even though you are the legislative body, because you are acting in an administrative capacity. So the court said, and this is a line from the case, that you cannot just have public clamor in the record to support a decision. That's not substantial evidence. And so the big takeaway from this is, when you have a decision, a land use decision, an administrative decision, one, you need to have a record, but two, you need to have substantial evidence in the record to support your findings and your conclusion. And so this is a spectrum, and certainly some decisions are more complex there's more discretion, and they're certainly going to be much more controversial. Certainly, conditional use permits sometimes can fit that description. And so if that's the case, one, you may want to involve an attorney just to make sure that you're properly documenting the process and the items that you're using to form your decision and to base your decision on. But two, you're going to want to make sure in any event that you have a good record and you have evidence. So it's not just people coming in and saying this or that. You're going to want potentially some expert testimony. Sometimes there are studies. You're going to want to have staff input, some back and forth, showing that you considered this. And again, it's a spectrum. There's not a right answer to this, because on the flip side is if you have a run-of-the-mill building permit application and someone can come in and show that technically they comply with the requirements of the code and they can give you the plans, then great, there's your substantial evidence. You don't need to have all these hearings and other sorts of testimony or having experts or studies. So just keep in mind that it depends on the level of discretion, and probably also you're going to want to consider the level of controversy that surrounds these decisions. That's going to be something that's going to be helpful in terms of how you create the record and what you're going to want in it, so that you can make sure that whatever decision you come to, it is going to be upheld. And keep in mind as well that, as I mentioned, the decision does not have to be necessarily the best decision as determined by a court. They're not going to weigh the evidence anew. They're just going to look and say, was there substantial evidence, meaning was there enough there that a reasonable mind could support this conclusion? So that's in my view, the takeaway from this. Moving on to variances. As we saw at the beginning, variances are one of the specific types of issues that an appeal authority has been charged to review and decide under state law. So a variance is a waiver or modification of one or more land use ordinance requirements that's applicable to a particular parcel. So this does not change the zoning code, and it does not apply throughout an entire zone. And as we'll see here as we go through this, variances are meant to address inequities that would arise by applying a strict reading and the letter of the law reading to the code to a particular property. Typically, there should not be probably all that many variances, and there's some standards that make them relatively hard to get. So this should probably not be thought of as a major tool in the toolbox to address situations, although it is one, and it absolutely does apply, and it can provide some very good relief to property owners. It's just that there are certain provisions that we'll go over here that have to be complied with. And then we'll also, as we did with the last one, we'll look at a couple of case studies to go over and get some more insight from what Utah courts have said. So on this one, not surprisingly, the applicant has the burden of proof. And so if you're the property owner coming in saying that I need a variance for this, well, you're the one that needs to show that you can meet the standards. Because again, this is taking and making an exception to generally applicable law. And so, that certainly makes sense. It would be that way. Variances will run with the land, which means that if you get a variance and you end up selling the property, that the variance you got will stay with the property to any subsequent owner. Anybody else that buys it, they'll have the same variance. They don't have to keep reapplying every time there's a new owner. This is an important one. Variances do not apply to the use of land. So if you have a parcel in a residential zone and you are saying because of things that are specific to my property, really the only use I can do here is a convenience store station, you're out of luck. You can't change the use. Variances deal with primarily things with like setbacks, buffers, potentially height, but things that are requirements that don't affect the nature and character of the use. If it's residential, it's residential. If it's commercial, it's commercial. It's not going to cross categories or allow a type of use that is restricted under one zone to be allowed because of a variance. And it's important here to note also that the appeal authority can impose additional requirements that will mitigate any harmful effects of the variance, so it's somewhat reminiscent there of a conditional use permit, and that will serve the purpose of the waived or modified standard. So if there's something that you can think of that will allow the property use be equitable to the property owner by granting a variance, but will also protect the public, then state law specifically allows that to be used. Okay, let's jump into the 5 standards that have to be met in order for a variance to be granted. And just our general impression and experience has been that these are certainly sometimes not all followed or sometimes ignored. But we're just throwing out here that this is what the state code says, you know, and what the law is on variances. So one is that the literal enforcement of the ordinance would cause unreasonable hardship for the applicant that is not necessary to carry out the general purpose of the land use ordinance. Okay. Now the code adds some additional factors here. The hardship has to be located on or associated with the property at issue. So it can't just be, well, you know, this is something that generally applies to the neighborhood, or it has to be specific to the property. It comes from, which is the second point here, it comes from circumstances peculiar to the property, not from conditions general to the neighborhood. And of course, the hardship cannot be self-imposed or simply economic. So the property owner can't shoot themselves in the foot and say, you know what, on second thought, I really shouldn't have granted that easement over my property that now prevents me from building that garage that I wanted to, and then expect to be able to come in once you were paid for that easement, and it was a decision. It was not through eminent domain. It was a voluntary decision that was paid for, and then come in and say, you know what, I don't meet the setbacks anymore for building a garage. Can I get a variance? That's not what is allowed here under the code. On the flip side, though, say UDOT came through and ended up widening a road and condemning or acquiring property under the threat of condemnation, so that now all of a sudden you no longer had the setback necessary to build a garage, and you just hadn't built yours yet, and most of the other homes in your neighborhood had garages. Well, that would be a situation where you would say the hardship's not self-imposed, and it is, it is something that would be more appropriate for a variance. When it's not economic, it's saying that, for example, everyone can get more money if they could just build a bigger house. If you could can you just expand the building envelope on my lot? There's nothing really that's unique about my lot. It's more or less the same size as all the other lots in the neighborhood. But man, if I could just expand it out a little bit, we could make a lot more money. Our house would be worth a lot more. That sort of thing is not what a variance is for. Okay, moving on. Number 2. So there are special circumstances attached to the property that do not apply generally to the other properties in the same zone. We hit that as a subpart, to that first part, because that's the way it is in the code as well. But it's its own special factor here as well. So the special circumstances have to relate to the hardship complained of. So just because you have a smaller lot, and you're trying to get some variance that doesn't have to do with a small lot, then no luck. And it has to deprive the property owner of privileges granted to other properties in the same zone. So if nobody's able to get a garage in the same zone, then it's not sufficient for you to want to get a variance so that you can get one when it's not. There's nothing particular about your property that is keeping you from getting one. Okay. 3, granting the variance is essential to the enjoyment of a substantial property right possessed by other property in the same zone. Okay. And 4, the variance will not substantially affect the general plan and will not be contrary to the public interest. Okay. And then 5, the spirit of the land use ordinance is observed and substantial justice is done. So, as you can see, we start getting to factors that are a little more, I don't want to say discretionary, but there's certainly a little more room to decide whether or not a variance would be appropriate or not. It's important to note that there are 5 factors that are mandatory, but this is not typically going to be a decision where there is a single right or wrong answer. It's important to keep that distinction. This is not an engineering decision where you can calculate something and there's going to be a right answer or a wrong answer. This is a factor test. You've got to look through it. You've got to weigh it. And and a lot of times it's conceivable that it would be okay and supportable to say there's a variance under these factors, and where it'd be conceivable and okay to say there's not a variance under these factors. It's just, there's not necessarily going to be a single right answer. I think that's important to understand here. Let's look at a couple of case studies. The first one is Wells v. Board of Adjustment here of Salt Lake City. This relates to the Market Street boiler there on 13th East and about 3rd or 4th South there by the U. It recently closed down, so it's no longer there, but it was there for a long time. And what happened is they ended up starting a restaurant in what was a historic fire station there that Salt Lake City used to use, and they sold and allowed to be converted into a restaurant. And it was in a historic district. And in that district, you had to have a 10-foot landscaping buffer in the rear of the building there. It applied to this parcel. And what happened is the restaurant grew. They initially had their garbage dumps inside their dumpsters, but as they became busier and busier, they had to move it outside for obvious reasons. And the problem is, though, is that they didn't have enough room to enclose these dumpsters as required by the ordinance and still meet the 10-foot landscaping buffer in the back. So they went and applied for variance, thinking, there's unique things about this property, and it's depriving us of a fundamental right, and they went through all these 5 factors. And the appeal authority ended up granting the variance. Neighbors got upset, sued, and the neighbors won. And the reason why the neighbors won is because the court looked at the record, and while they had a conclusion, they did not have substantial evidence in the record for each one of the 5 factors that had to be looked at and had to be met in order to support the decision. And so the court overturned it. Now, a short time later, the garbage dumps appeared in the back of the restaurant because the owners of the restaurant went back to the board and they went through the 5 factors, and this time the board made the necessary findings, included the substantial evidence in the record, and that was one they were going to win. And so, it's important to remember, just like with the decisions generally that we just talked about, you've got to have substantial evidence in the record for your decisions, or they are subject to being overturned on appeal. So that's just the law, the way it is, and doing so will really help in making sure that the decisions you make will be sustained on appeal. Another case here, Save Our Canyons v. Board of Adjustment. So in this case, this relates to property at the mouth of Big Cottonwood Canyon, and it relates to an access road in the mountains there to this property. And initially, they had the plan of having the access road running close to the water treatment facility that's there at the mouth of the canyon. And after 9/11, because of its close proximity to the water treatment plant, they said, you know what? You got to move this road. As a security issue, we can't have a road this close to this plant, and so we're not going to serve you with water unless you move your road. The problem, of course, is that there's not a whole lot of options in mountains to run a road that's going to meet the standards of a zone. And so they applied for a variance, went back and forth. They worked with staff. They ended up changing their plans, and this went back and forth multiple times. And ultimately, they were able to come up with something that staff supported, and it greatly reduced the number of variances they were requesting. And the Board of Adjustment ended up granting the variance. Again, folks, neighbors that are sued, and the court in this case said, you know what, if you are suing trying to overturn a decision, you need to show why the evidence in the record was not sufficient to support the decision. Because in this case, there was evidence that was there that could have been used. And they did not do that. And so the court said, you know what, that's on you guys. You guys have to do this. You didn't do it. Therefore, we're going to uphold this decision. So I would say that, a couple of takeaways, hopefully, from the conversation or what unfortunately turned out to be more of a monologue today, is follow your ordinances. That's nothing new. Follow your ordinances, and when you're making these types of decisions, make sure that whatever decision it is, on the administrative decisions, which is the vast majority of the decisions we're talking about, and the only ones that go to appeal authorities, at the local jurisdiction level. So make sure that those decisions are supported by substantial evidence in the record. Okay? It's important that they be part of the record. And so when you do that and follow your ordinances, you have a high likelihood of being able to have your decisions upheld on appeal. You have a high likelihood of making legal decisions in the first place, and you have a higher likelihood certainly of respecting people's due process rights. Because again, and I think it's sometimes a little easy to forget this, that when we are dealing with property, these types of land use decisions, they are property rights, and they are property rights that are protected by the United States Constitution as well as the state of Utah. And so, these are important issues, and there are laws and situations and protocols set up that will help respect those rights and make sure that people are making good decisions that will be upheld. With that, I would say any other questions I'm happy to entertain. And certainly if anyone wants to call, feel free to give us a call. I promise I won't talk so much on the phone, and we can keep the conversation going.
Great. Thank you very much for that excellent presentation. I'm just looking here. It doesn't look like we've had any additional questions come in, with the exception of a question if we'll make the slides available. And as long as Jim's okay with that, we'll send out a PDF of those slides.
And please, use use the slides that have way too much stuff on them as a reference. I'd love that if it were helpful to anybody. So.
Yeah, definitely tons of information here. Let's see. I am not seeing any more questions, so I think you must have totally enlightened everybody on here. Now they know there will never be another question about appeals and variances again. So
that's a very charitable reason.
Thank you very much. We appreciate the effort you put into putting this together for us. This is a valuable resource, and we appreciate everybody attending here. Use the resource. We're recording this session, and we'll place it up on the website. There's also I can't remember. I haven't counted. Probably close to a dozen additional webinar recordings out there on various subjects, and so refer back to and use the resource, and really, that way we can stay out of trouble and really protect people's rights as we're trying to do the best things for our communities. So, thank you very much. Final thoughts. Final thoughts.
I think I've exhausted my thoughts today. So.
All right. Thank you very much. Appreciate it. Everybody have an awesome day, and we'll see you again soon.
Thanks, Jason.